Morning, Council. The next case is People versus Welsh. Also a mini oral argument on the application. Mr. Baker, that means you can try and reserve some of your 15 minutes, and you may proceed.
This case presents two questions that have been vexed the Court of Appeals. One has to do with the choice and application of an appropriate harmless error test in a jury construction error case, and the other has to do with the evaluation and measurement of Beck sentencing error. I will discuss each of those issues in turn, but first I would reserve the balance of my time for rebuttal and also invite the court's questions at any point. There's no dispute here that when the judge gave a supplemental instruction to the jury, permitting the jury to use a transfer intent theory in the conspiracy charges, that she committed a mistake. The Court of Appeals so held, and the prosecutor concedes as much here. So the only question for the court's review is whether that was reversible error. The court decided it was not, but it made two big mistakes in doing that. First, it failed to acknowledge that this was constitutional rather than non-constitutional error. That was an issue that we presented to the court through our briefing and our argument, arguing that this was a due process violation of Ms. Welsh's right to have a correctly instructed jury on the elements of the offense. The court simply never reached that question in its decision. The court's second error was that the harmless error test that did apply for non-constitutional error, it applied incorrectly. It ruled that there was not evidence of there was reason to reverse here because there was sufficient evidence apart from the transfer intent theory to support conviction. Well, that's not an appropriate test under any approach towards harmless error review. It certainly isn't an appropriate approach in a case that involves jury instruction error where the courts have been careful to look not to what they would have decided, but to whether the instruction impacted an issue that was before the court, significantly before the court in the case of a non-constitutional error. In the constitutional error context, it doesn't have to be very much at issue. All that needs to be shown in order to justify a retrial is that the error was harmless beyond a reasonable doubt, which means, or that it was not harmless beyond a reasonable doubt, which means that under the Netter decision that I cite, that the evidence to convict was not overwhelming and that the issue is not contested. In the non-constitutional context, that more is required. It's not a defendant's burden to show that the error was harmful. But all that means is showing that this was the issue that was flawed or not given was legitimately at issue in the trial. Cornell, the case that the Court of Appeals here invoked but didn't follow, made it clear that you don't just look to see whether the untainted evidence supports conviction, or in that case where there's a missing instruction that the evidence that was presented supports conviction. You have to look to see whether the issue was presented to the jury, whether there was, in Cornell's words, clear evidence or substantial evidence to the missing instruction. That's enough. It's not up to the reviewing courts at that point to say whether they think the jury would have followed the missing instruction as in Cornell or not followed the flawed instruction that was given as in this case. What the Court of Appeals here essentially did was say, unless because there was a basis that the jury could have convicted Ms. Welsh without looking for transfer intent, that's enough. That unless the jury had convicted her on something on a transfer intent theory, there was no error that required reversal. That can't be the correct way of looking at it. So for those reasons, we're asking the court to remand for retrial. But we're also here on the Beck issue, and the Beck issue here is.
Before you get to that, let me just ask a question that's, I don't know if it's on the point or off the point after your presentation, but As I understand it, the defendant was only charged, that was with the conspiracy, not for the first person that they all had agreed to go over there to shoot, but with shooting at the other two people, that apparently, after driving around for a while, they went back and shot at the people who were on the porch. This case causes me to scratch my head, but is there enough evidence that there was an agreement to shoot the other two people just based on the fact that they drove around and went there and did it? And if so, wouldn't every time a group of people go do something, would that be sufficient to support a conspiracy charge?
I don't think there is enough evidence. I know the judge always found otherwise and the Court of Appeals found otherwise. But to keep this in perspective, you have to look at the fact that the prosecutor didn't even argue this theory to the jury. The prosecutor based the entirety of the case on a transferred intent theory.
Well, with the transferred intent as to the principal assault charges, right? And where it made some sense and where that seemed to be the focus of the case, and then there's an acquittal on the main charges, and here we are on some, I don't want to call them satellite charges, but.
As best I understand it, Your Honor, these were tag-along charges. They were.
But they're the wrong tag-along charges. Why didn't they tag along, I guess I'll ask your opposing counsel, why they didn't tag the right charge along?
We are puzzled by the same facts, Your Honor.
All right, I just wanted to make sure I was not.
I think the conspiracy charges were a bit of an afterthought. And it wasn't.
Or was it a wrong thought? I mean, didn't they just charge the wrong conspiracy?
Yes.
Okay.
Yeah, the conspiracy was against DT. That's what they presented evidence of. There was no conspiracy against Barry and Jones.
Okay.
The Court of Appeals thought that there was enough evidence that, based on Judge Bowie's findings, that they had a last-minute change of mind and they decided to shoot at the people on the porches.
Well, the juror who was apparently, the juror who was apparently one of the better lawyers in the courtroom said the same thing with the question, right? Why are we here when the intent was, or the agreement was to one guy, why are we talking about these other two?
That's absolutely right. And also, with respect to one of the victims, Jones was inside the house, so it's not even clear that anybody could have seen Jones when they were circling around the block and formulated an intent, tacit and unspoken, to change the focus of the conspiracy from DT to Barry and Jones.
Case sounds like it should end in,
At best, a very weak case of a conspiracy against Barry and Jones.
I was gonna say something, but I won't. I'll withdraw.
I'd like to hear from the other side on these issues, but if there's more you want to add on other issues.
Yes, with respect to that,
Your time.
I know that the Court of Appeals has been struggling with that, we're trying to evaluate and measure that error. We know that from some of their decisions. It seems from those decisions that the one that they're having the most problem with is the case, mostly hypothetical, I think, in which there are conflicting verdicts. The jury finds, based on one count, that the defendant committed a certain behavior, and then based on another count, acquits that same behavior. Fortunately, that
But couldn't just the reference to her involvement just be acknowledging her presence? I mean, judges all the time give context when they're doing sentencing, recognizing they're not supposed to rely on acquitted conduct, I realize, but, it seems like it's a fine line here.
But involvement in the shooting really isn't anything different than participating in the shooting. It wouldn't make sense to hold her responsible for involvement in the shooting if the judge didn't think that that meant that she was responsible for the danger created to those people by the firing of the weapons, by participating in the shooting.
Well, to the extent there was a valid conspiracy charge and conviction, couldn't it just be involvement with the other people who were the shooters?
So she was involved in the planning, she wasn't involved in the shooting itself. I know it's a fine distinction, but that's,
But aren't you stuck with all the acts taken in furtherance of the conspiracy, including the shooting? If you're the co-defendant?
again, the conspiracy was against DT. The prosecutor was asking the jury to transfer intent, so the acts in furtherance of the conspiracy, what were the acts?
I'm too confused by this case and that hypothetical to keep going, but the conviction was on these other people that apparently were around, I don't know. But
In any event, I hope that we don't need to have resentencing, that will have to be filed instead. If the court doesn't have any further questions, I will reserve the balance of my time.
You may.
Thank you.
Good morning. May it please the court, Paul White on behalf of the people in the Saginaw County Prosecutor's Office. Listening and frankly being familiar with this case, I anticipate you to have some questions for me, so I'll just get right to it. Obviously, as the fourth appellate attorney on this case, I'll do the best I can.
We understand.
Try to manage, frankly, inconsistent jury verdict and somewhat inconsistent arguments over the course of several years, but here I am.
So the hard question is, why was the defendant charged? I mean, it shows the importance of whoever's in your office authorizing warrants, right? So why is the defendant charged with the conspiracy of the two instead of the obvious conspiracy charge?
That's a good question. That was raised 6 years before I started in the office, roughly. So I don't have an answer to that question. What I can say is, since I've come in, one of the things I've focused on is being more specific in when you're charging conspiracy going forward. But in terms of why this was charged, the specific conspiracy charge it was in 2017, I can't remember.
Okay.
No, so frankly, most of our officers have been over the last 5 years. So there's really no additional knowledge in regards to that.
Okay, but I guess for our purposes, you agree that the charge seems a little bit off.
Yes.
Okay, that's fair.
I'm not here to blow smoke.
No, it's fair, and
There's a lot that's,
I
unique about
appreciate,
this case,
I appreciate your candor and your
Yeah.
presentation, and you have a difficult job, and I think you handle it well.
Does anyone have any questions? No. Thank you.
No, thank you.
I realize I have a balance of time, but
But you might not need it.
I think the court does not have further questions.
Thank you
If
very
there
much.
is a new trial in this case, maybe there'll be a plea bargain, because my informal jury poll is that they appear to be convinced on the one conspiracy charge. Sort of a slam
There,
dunk.
there might be a new conspiracy charge.
Yeah, right. Right. I don't get to say that from up here anymore. As a trial judge, I can do that work, but not up here.
You just did.
Right, I know, that's the first time. Trying to hope it's not improper. Justice Harris, is it improper?
No comment.
Thank you both.
Good
The
luck.
case will be submitted.
Good luck.